Uh, Thank you so much, Vijay, for inviting me to this presentation. Thank you, Dr. Marta. Do you accept my thanks? Thank you for organizing this conference and inviting me to just make my own contribution. Thank you, everybody. And Professor Christian Tete, thank you for coming, and I'm happy to see you again here in our law school. Thank you, everyone. My title is, as you can see over there, Resolution of Capital Market Disputes in Ethiopia, Critical Legal Analysis. In fact, this paper is co-authored by Mr. Sarkalem Shete, who is not just around to make the presentation because of his personal reasons. Therefore, I discharge my, I make the presentation in my personal capacity and representing Mr. Sarkalem. I expect that much has been said about capital market in Ethiopia in the previous just sessions. In Ethiopia, as you know, capital market was introduced for the first time in 2021 through that just proclamation. And as you just see from the capital market proclamation, there are various actors, participants and actors. And therefore, there's a participation in the involvement of these actors obviously entails economic interactions. And naturally, this economic interaction inevitably, brings about disputes. Dispute is, just inevitably associated with, just commercial dealings, commercial interactions, and economic activities. And therefore, a system of capital market worthy of the name should put in place, a workable, efficient, adequate, and a comprehensive, adequate and a comprehensive dispute resolution system. That is why, as we can understand, different jurisdictions have put in place various dispute resolution mechanisms, and Ethiopia is not, just an exception to this general practice. Therefore, Ethiopia, in fact, just has put in place dispute resolution, just mechanisms for, capital market disputes. But the question is, however, is whether Ethiopia has, put in place adequate, clear, efficient capital market dispute resolution mechanisms. That is the most important question. This piece is therefore aimed at examining this central question in light of, just the general literature and in light of the available legal framework in Ethiopia, particularly, just evaluating the proclamation in light of the Ethiopian Arbitration and Conciliation Proclamation, the Ethiopian Civil Procedure Code, and other important laws. Therefore, to just answer this important question, we basically used, the doctrinal approach. Therefore, our, just purpose is to critically examine not just the law. We don't not, we didn't delve into the practice as such because the practice is not yet developed. But when, just the paper takes its final shape and the texture, we're going to include, the views of, just scholars and practitioners by way of interviewing. The paper is organized, just into the following sections: introduction, participants of capital markets, disputes. Section 3, general overview of methods of capital market dispute resolutions. Section 4 deals with capital market dispute resolution mechanisms in Ethiopia. And finally, we have made some conclusions and recommendations. Needless to say, capital market generally involves, just as I said previously, important, unavoidable, indispensable participants. These are, for instance, issuers, investors, intermediaries, regulators, and the like. Therefore, the presence of, just these, participants inevitably, as I said, entails disputes, because disputes are, just part and parcel of economic activities and interactions. Therefore, we have to put in place, just dispute resolution mechanisms. Generally, in the world, we see, when we just, assess the practice in the world, we see capital market disputes are, just resolved by arbitration. That is not just the most important one. The other important mechanism to be used to resolve capital market disputes is mediation. And the third one is, in some jurisdictions there is regulatory or ombudsman mechanisms. In others, there is what is called stock exchange grievance committees. The fifth, obviously, is litigation. That is, just the orthodox way of resolving capital market disputes. And last but not least is conciliation is also used for resolving capital market disputes. Coming to Ethiopia, when we come to the Ethiopian reality, in fact, the capital market proclamation has put in place very expressly that capital market disputes should be first resolved by mediation, and mediation under the proclamation is a mandatory procedure. One cannot, just dispense with mediation. Mediation has to be tried. First of all, you will have to face the process. So, just the agreement is, just consent-based. The question, the most important question that we need to under the Ethiopian scenario is as to why mediation is selected, or chosen as opposed to conciliation. While we have, adequate, comprehensive, just legislation as far as conciliation is concerned, the lawmaker left out, right, the Ethiopian arbitration, the conciliation procedure proclamation, and it has opted for mediation. Just that is an important question. The other important question is, just as to why mediation is, just made compulsory. Anyways, despite these questions, anyways, mediation as a process is a mandatory, just procedure that needs to be followed by disputants. But the problem still is, instead of, beyond talking about mediation, the Ethiopian legal framework as a whole does not have, just detailed provisions, as far as the definition of mediation is, as to how mediators are selected, their composition, their, just the impartiality requirement, independence, and the outcome of the mediation process is not clearly regulated, right? For instance, when we come to the outcome, is the outcome simply an agreement, or could it be taken as, just as a decree that can be executed by a court of law? Remains to be, just an important question under the Ethiopian legal system. The other, just dispute resolution mechanism recognized under the capital market proclamation is compulsory arbitration. It says that arbitration is compulsory, and an award of an arbitral tribunal, be it ad hoc or constitutional, is binding and final. So, just appeal is possible as provided under the Civil Procedure Code of Ethiopia. Still, the question is that, just crosses my mind at least is, why is arbitration compulsory? While arbitration in Ethiopia generally is, just consent-based. Why should it be, just made compulsory? What could be, just the policy justification? There is a justification, but the justification is not satisfactory to me. Why should, arbitration be imposed on parties? Shouldn't it be, just consent-based, and shouldn't it, honor the autonomy in the decision of the parties? Is the more important question that needs to be considered. Despite this, just be this as it may, still the rules contained in the capital market proclamations are very, very, very narrow, right? One article 111, is devoted for arbitration and mediation. But the problem still is, okay, this proclamation has not made any clear reference to the Ethiopian arbitration and conciliation working proclamation, which relatively contains advanced modern, just rules of arbitration, starting from, the very beginning of arbitration proceeding, through the proceeding and up to, just the final recourse, right? Therefore, if a cross reference is not, just made, okay, to the arbitration, the conciliation proclamation, how could, just important issues, remaining issues be dealt with? For instance, recourses, for instance, how can an opposition be filed? Because, opposition is regulated in the arbitration, the conciliation proclamation, but it is not, the capital market proclamation has not made any cross reference. That is one. Secondly, the capital market proclamation has made, cross-referred to the Civil Procedure Code, but the saddest part is the Civil Procedure Code was repealed by the Ethiopian Arbitration and the conciliation proclamations. Proclamation, right? Long before the coming into force of the capital markets proclamation. When I say that the civil procedure code is repealed, I mean the provisions of the civil procedure code dealing with appeal are repealed, right? Therefore, what is the recourse, just that we have? How can we, just file and, just appeal against the decision of an arbitral award? That is, just an important question. Most importantly, the other important, just recourse is setting aside of arbitral proceedings. That is an important procedure. But the setting aside provisions of the Civil Procedure Code of Ethiopia were repealed by the Ethiopian Arbitration and Reconciliation Proclamation. So how is, setting aside proceeding conducted in Ethiopia? Or does this mean that we don't have any recourse, right? To get, just an award to set aside by a judiciary? That is, just an important question that we have. Now, the third, dispute resolution mechanism is the judiciary. In fact, the capital market proclamation has not made any, just reference to the judiciary, but it says, it tangentially says that appeal may be made, right, as provided under the Civil Procedure Code. This means that Ethiopian courts do not have first instance jurisdiction as far as the resolution of capital market disputes is concerned. Therefore, they have appellate power. The courts do have appellate power, but the provisions of the Civil Procedure Code dealing with appeal have been repealed, and the capital market proclamation has not made cross-reference to the appeal provisions of the Ethiopian Arbitration and Reconciliation Proclamation. This is, just a serious legal vacuum, right? Very serious problem. I see this problem. The other important, just point is the role of the judiciary as far as opposition is concerned, setting aside is concerned, and their roles during the proceedings, for instance, in removal of arbitrators, appointment of arbitrators, right? Disqualifications, and in taking, interim measures during the arbitration proceedings are not adequately regulated in the capital market proclamation. Okay, these are not just the problems. Anyways, we can say that by way of interpretation, one, courts do have, just inherent power to accept, just disputes or at least appeals, oppositions, setting aside, just proceedings, although the law is silent. The other, just role of the courts, obviously, is, just cassation. They can review and, just a decision, an arbitral award by way of cassation, because cassation is entrenched in the federal constitution, one. Secondly, power of cassation for courts is clearly provided under the federal courts proclamation, because it clearly says that the cassation division of the federal Supreme Court has the power to accept and entertain arbitral awards made by any arbitral tribunal, be it, an ad hoc arbitral tribunal or an institutional tribunal. Generally, in fact, Ethiopia has, just put in place dispute resolution mechanisms relating to capital markets, but still the legal framework is not adequate. Okay, it is filled with, just gaps, voids, and the problems. The other important thing is, even the proclamation, the capital market proclamation, has not, contained detailed rules, nor has it made cross-reference to the Ethiopian Arbitration and Reconciliation Proclamations. Rather, it is, just a reference to the repealed provisions of the Civil Procedure Code is still a problem. And I see that, just there is no, just harmony between the Ethiopian laws. And I think the drafters of the Capital Market Proclamation, I imagine that, just they didn't make, serious reference to the Arbitration and Reconciliation Proclamation, the Civil Procedure Code, and other important laws of the country. Therefore, you see contradictions, voids, gaps, uncertainties, and hence we can safely say that the Ethiopian capital market dispute resolution system lacks, just legal certainty, just legal certainty. Therefore, we recommend that one, the recommendation just that we want to make is one, in view of, just all these problems, we recommend that the capital market proclamation has to be amended to make it very clear, adequate, efficient, and harmonious with just other laws of the country. Look, when amended, one, either it has to contain detailed just provisions on mediation and arbitration, in fact, on means of recourse against arbitral awards, or it has to make cross-reference to the arbitration reconciliation proclamation of Ethiopia for duplication of effort is not needed. Cross-reference is not just a wise choice. In the meantime, however, the Ethiopian Capital Market Authority has to issue directives because the law has envisaged that the capital authority, the Ethiopian Capital Market Authority would issue directives, right, with regard to not just arbitration. But we can say that it has the power to issue both on mediation and arbitration in the meantime. But look, I argue that regulating carefully dispute resolution mechanisms is an essential power which has to be exercised by the lawmaker, and the point that I have raised so far should not be relegated to just directives. The primary legislation should be amended, and these problems, deficiencies, uncertainties, and just vagueness should be remedied. Thank you so much.
Okay, thank you, Dr. Aschalew. That's very, very good, very eloquent. Yeah, very logical and coherent. Thank you. Just by way of a brief summary of the highlights to help the participants in catching the main points. Aschalew has looked at the legal framework, the Capital Market Proclamation, the Civil Procedure Law, and the Arbitration and Conciliation Proclamation that regulates dispute resolution in Ethiopia. He also has looked at, has presented the existing and the unresolved problem in Ethiopia in the different institutions of dispute resolution, this mediation, conciliation, and arbitration, especially the Capital Market Proclamation, making wrong cross-reference to a repealed civil procedure proclamation or law instead of making reference to the arbitration and conciliation proclamation. And many of the problems that Dr. Aschalew raised relate to this wrong cross-reference to repeal law instead of making cross-reference to the arbitration and conciliation proclamation. And by way of conclusion, he asserted that Ethiopian capital market dispute resolution system is inconsistent and uncertain. And he also recommended that the capital market proclamation should be amended to either come up with detailed mechanisms of resolving disputes, or it should be amended in such a way that it makes cross-reference to the civil procedure. The arbitration and conciliation proclamation. And in the intermediate, he also suggested other solutions. Thank you, Aschalew.